A day after his petition was struck out by the Supreme Court, Dr Ekuru Aukot, through lawyer Elias Mutuma, has moved to the High Court seeking interpretation of Article 140, Section 3 of the Constitution, as well as orders barring IBC from printing presidential ballot papers, pending hearing and determination of his petition. Aukot says the Commission's chair Wafula Chebukati published the names of Uhuru Kenyatta and Raila Odinga in Kenya Gazette dated 15th September 2017 as the only presidential candidates for the fresh election as directed by the Supreme Court of Kenya. Aukot says that IBC chair has ignored the provision of the Constitution and clearly acted in bad faith. Having participated in August poll, Aukot says the Constitution allows him to participate in the fresh election after the Supreme Court annulled the election of President Uhuru Kenyatta on account of illegalities and irregularities established during the hearing of the presidential election petition. And High Court Judge George Odunga has set aside a petition tabled before Parliament's Finance Committee to probe Auditor General Edward Ouko. Odunga in his ruling says the conduct by the Finance Department failed to meet the threshold of fair administrative action. Judge Odunga, however, declined to quash the decision by the Speaker of the National Assembly and Departmental Committee on Finance and Trade to probe Ouko. Meanwhile, a death row inmate, unhappy with the judgment that saw his case against a senior prison officer thrown out, has vowed to appeal the judgment at the Apex Court. Joseph Nyanjui, who is serving a life sentence for robbery with violence, said Justice Chacha Mwita was not fair in his judgment, having not perused his documentary evidence.
You present the evidence and the judge don't even intend to go through the document that you present. I also understand that the respondent had met with the judge. I will not disclose where they met, but I will be bringing these issues to the Judicial Service Commission for removal of the judge.
In the case, Nyanjui had sought compensation, claiming that a senior officer at Committee Maximum Prison, where he is serving, had assaulted him, causing him serious injuries. While dismissing the application, Mwita said the applicant did not provide sufficient evidence to warrant compensation.
On the record, there is no evidence that the petitioner was targeted as a person. This was an exercise targeting the whole block, which was suspected to have contraband goods. In that regard, therefore, I am not satisfied that the petition has made a case for grant of the order sought.
Finally, 2 men have been charged with conspiracy to defraud and obtain goods worth over 26 million shillings by false pretense. Mapili David Mapili, alias Vincent Ambonyi, and Peter Mwanga, who denied the charges before Chief Magistrate Francis Ndai, were each released on a 1 million shillings cash bail. They are said to have conspired to defraud Joysha Enterprise on diverse dates between 3rd June and 21st of July this year, on pretense that the said iPads and laptops were acquisition from the Ministry of Health. Ben Chumba reporting for Scales of Justice.